Hello. All persons having business before the Honorable Chief Judge and Associate Judges now presiding of the District of Columbia Court of Appeals. Draw near and give your attention. God save the United States and this honorable court. This honorable court's now in session. Please come to order.
All right, good morning, everyone, and welcome to the District of Columbia Court of Appeals to our virtual oral arguments today. As you know, we've been doing our virtual oral arguments in light of the COVID-19 pandemic to protect the health and safety of the parties and our court staff. So we ask your patience this morning. We have been working hard to deal with the technology issues, but in the event that there are some glitches, we ask for your patience this morning. At this time, we have two cases set for oral argument today. The first is Robert McMillan versus United States of America. Are the parties ready to proceed?
Yes, Your Honor. Good morning.
Yes, Your Honor. Good morning on behalf of the appellant.
Okay. All right. Mr. Kirsch?
Good morning. May it please the court, Stephen Kirsch on behalf of Robert McMillan. I'd like to use 10 minutes for my opening argument and reserve 5 minutes for rebuttal.
Okay.
I'll start by saying that, obviously, as everyone is aware, this case has a very lengthy history. It's been up before this court a number of times. It's been back in the trial court a number of times. But I would submit to the court that at this time, the issue remaining for resolution is whether Mr. McMillan, the appellant, was prejudiced by the post-trial Brady disclosures of March 24th, 2010. And when I talk about the Brady disclosures, my review of the record and my evaluation of the post-trial record is that the Brady issues encompass both the presence of the diagnosed post-traumatic stress disorder and the undocumented multiple personalities. But again, just to repeat, it's not that one is separated from the other. I believe that they were provided to trial counsel as a combination, and that the thrust of this court's opinions related to that relate both to the PTSD and the multiple personalities. So,
Mr. Kirsch, I'm sorry to interject, but I wanted to know if you could clarify something for me. My understanding, in closing argument at trial, the government actually refers to the alleged multiple personalities. And so my understanding is that that's not the specific part of the subsequently discovered Brady material that is at issue here. I thought the only thing at issue from the Brady material, the alleged Brady material, was Ms. Harrison's statements in another trial where she refers to herself as a liar. Because other things like the alleged multiple personality disorders were known, at least at the time of closing argument, and are part of some of the closing argument statements by the prosecutor. Isn't that correct?
Well, I believe it may be correct, but the post-traumatic stress disorder, and again, I go back to the March 24th, 2010 letter, the post-trial letter from government counsel, where they identify the PTSD and the multiple personalities as evidence that had not been previously disclosed. So it's from that point on that I would submit to the court where the Brady issue really arises. And there's nothing in the record to suggest that trial counsel had this information or was able in any way to document this information such that they could have used it in cross-examination of Ms. Harris.
But I thought the trial, I'm sorry, referenced it in his order, that this was part of some of the arguments of government counsel. Now, maybe I just am misunderstanding that from the record.
I don't believe so. I believe that this is all this information as to both of the ailments was disclosed after verdict. And so it could not have served as a basis for cross-examination or for the introduction affirmatively of any type of evidence so that the jury could understand the nature and the consequences of either of these ailments. And so Judge Christian determined that there was not a reasonable probability of a different result, even had this information been known to trial counsel. And I would submit that that is incorrect, respectfully submit that it's incorrect, and that Brady evidence is not just exculpatory evidence, it's impeachment evidence. And this court has held that on numerous occasions. Other courts have held that on numerous occasions. And this information, the presence of post-traumatic stress disorder, which we talk about extensively in our opening brief, clearly was not known to trial counsel. And
was it known to counsel on remand at all?
oh yes, it became known to counsel on remand because that was part of McMillian too.
Well, on remand, the only indication that I have read from the briefs and otherwise that the PTSD is focused on memory issues. And I didn't see anything in there that indicated any basis, and there was no expert proffered at the remand hearing to go any further with this, that PTSD would tend to cause one to be a congenital liar. And I think what you have to be arguing here is that because she lied in McQueen, there's also an indication she must have lied in this case. And, you know, you have to have some foundation more than that, don't you?
Your Honor, I agree with some of the comments that the court just made. And clearly there was not, at the remand hearing, expert testimony was not introduced, but it should have been.
Yeah, you're sort of stuck. And I understand and respect this position you're in because you have no foundation other than the fact that PTSD was acknowledged to indicate that therefore caused her to lie over and over again. And you put a lot of literature into the brief, which is very interesting, although even there, the focus seems to be on memory loss, which I don't know ties at all into lying.
Well, PTSD, again, it's a very, very serious ailment, and it affects the person's ability to perceive things. And that's where I believe an expert should have been introduced at the remand hearing to address those matters, just how significant the ailment is, not just on
Well,
memory.
are you claiming this is an ineffective assistance case at this point?
Well, what I'm initially arguing is that it was plain error because of the fact that in McMillian, this court, I believe, was urging the trial court to consider expert testimony. And I believe Judge Christian should have gone further than just ask about medical records. He should have asked about expert testimony. And the reasons are that this court also noted this was not just your ordinary impeachment testimony, which Judge Christian relied on in affirming the conviction. Your ordinary impeachment is, well, you were wearing glasses, you know, what were the lighting conditions, what were the weather conditions? This was something, as this court recognized, was significantly different because this went to a mental illness, a documented mental illness. So my initial argument is that it was plain error and that Judge Christian should have invited counsel to introduce expert testimony. That's the record that I inherited.
Well, and I agree with you. That's a very cogent, clear, responsible way of presenting your argument as plain error. I think that probably is the closest you can come, isn't it?
Yes, but when you and I appreciate that, but when you look at Ms. Harris's testimony in the context of the whole trial, she was the government's case.
Well, but can we explore that, because there were other witnesses, right? who testified, and how relevant is her testimony, specifically when you look at the fact that there was a mistrial on the robbery count? Didn't most of her testimony go sort of very strongly to that robbery count?
I agree, Your Honor, that it went very strongly towards the robbery count, but it also went to the homicide account. And I mean, she's the only witness who says she sees and identifies Mr. McMillian as the shooter. She said she didn't see a gun, but she puts him on the scene in his van right there at the scene. The other witnesses were truly, and this court recognized that in McMillian too, they had significant credibility problems. Two of them would testify.
Well, but she did too, and many of those were highlighted through the cross-examination, which is what the trial judge essentially says in his order. And I'm looking at his order, footnote 4 of the trial judge's order on page 7, where as the government counsel is wrapping up and closing argument, they are referencing, according to the trial judge's order, her multiple personalities. He says, now we have Cynthia Harris. She came in and you remember her, Cynthia Harris, or Camilla Taylor, or Cece, depending on what she's involved in at the time. She changes her name. I mean, so these points came out in cross-examination. And it seemed to me that the multiple personality claim was pretty strong impeachment against her, particularly against the backdrop that it wasn't really substantiated by the medical records. I know you're relying on the PTSD, which maybe didn't come out as much, and the use of the specific words liar, although that was clearly implied in a lot of the cross-examination. And so I guess I'm struggling to see why this wouldn't have been merely cumulative, because she was effectively cross-examined and not credited. And maybe that's in part what led to the mistrial on the robbery count as well. The jury just didn't believe her.
Well, it's hard to delineate with respect to impeachment at what point you're entering into that territory where it's cumulative, as opposed to enhancing your argument as to the lack of credibility of the witness.
Mm-hmm.
So again, I'd go back to this court's opinion, McMillian 2, where the court clearly says that this is not your run-of-the-mill garden variety impeachment. This is significant. This is something different, something more significant. So I would submit on those grounds that where you have a medical ailment, and a very, very serious medical ailment that can affect different people in different ways, the genesis of it can be from any number of ways. She clearly, in my view, is that the expert testimony was absolutely necessary to educate people. I mean, we as lay people, medical lay people, we all have some sense of what PTSD is, but this is the type of testimony that really screams out for an expert to come in and explain the parameters of it. I use experts in PTSD all the time. I don't try to explain it myself. I have an expert do it. And
well, counsel, are you saying that the court should have called the expert? The court should have told counsel to take a continuance and find an expert? How would this have happened?
That is what I believe, is that the trial court, and I'm not just creating this issue, I'm basing this on the information and the language from McMillian 2, where the court seemed to be really urging consideration of an expert witness. And the last sentence in McMillian 2 says that the trial court should hear from testimony as needed, as well as witnesses who can shed additional light on the information regarding her multiple personalities. That could only come from an expert witness. It couldn't come from Ms. Harris. It couldn't come from a lay witness. It could only come from an expert witness. And the nature and substance of this type of testimony, I would submit, really requires expert testimony. And Judge Christian was set what was required to follow the instructions of this court on the remand. And so I would submit that it was plain error, that is something that Judge Christian should have at least sought, because he was inquiring about medical records. He did have legitimate concerns about the medical history, but he didn't go far enough, I would submit, in requesting expert testimony. So if it's not plain error, my backup position would be there should be a remand back down to Judge Christian so that expert testimony could be introduced, so that the full record could be considered with a full evaluation of, as this court said, all available witness testimony.
All right, Mr. Kirsch, we'll have you be able to reserve some time for rebuttal. Ms. Carroll?
Thank you.
Thank you. Good morning, Your Honors. May it please the court, Ann Carroll for the United States. The record, I must begin with the clarification of where the record stands. We'd submit that first, Judge Christian's denial of appellant's 23-110 motion is amply supported by the record. And the sole issue that appellant raises for the first time on appeal, having to do with the post-traumatic stress disorder, the PTSD. One, it's not properly before this court because it wasn't raised by trial counsel below. And in fact, it is inconsistent with the position appellant took at the trial court below. So based on this court's decision in Bradley, I would submit that argument is not properly before this court. Moreover, appellant, even if this court were to consider that issue for plain error, appellant cannot establish plain error. The record as it stands, and first, this court's decision in McMillan 2 was that Judge Christian should not have denied appellant's motion without the benefit of a hearing. It was not to make any determination or finding on the existence of a multiple personality disorder or the impact of any mental health history that the witness had. Indeed, it was the fact that there were these open questions that this court required Judge Christian to conduct a hearing to explore multiple personality disorder. Now, Judge Christian had asked the Judge Christian's question, I think that it is highlighted by appellant's counsel in his brief about where the psychiatric records actually wasn't Judge Christian asking for the medical records. He actually already had them. He was at that moment on page 37 of the December 7th transcript from 2000 and I believe it was 16 was playing out. He went through the mock trial exercise of how would this cross-examination have played out, because there was no medical record that documented that Ms. Harris had been diagnosed with multiple personality disorder. Now, it is true that all of the parties had recognized a history that Ms. Harris reported to the DC jail in May 2006 or just June of 2006 when she was held on a material witness warrant. And that is the reference, the isolated reference to post-traumatic stress disorder and a history of a diagnosis or a history of treatment for post-traumatic. We do not know when that occurred, but what we do know is in the McQueen trial, Judge Satterfield, who presided over that matter, had reviewed these exact medical records and had explored what, if any, part of Ms. Harris's mental health history was appropriate or relevant to cross-examination. Defense counsel in that case, who was a public defender service attorney, did not even assert that there was any basis to explore the witness's mental health history, had never even suggested that post-traumatic stress disorder in the past had some bearing on the witness's ability to relate or recall the events that she'd witnessed in the McMillan case, which was in 2000, I believe it was 2004.
Ms. Carroll, can I interject
Yes.
there with a question? Maybe you could clarify for me. Why didn't this so-called Brady material come to light sooner in this McMillan case? The government was aware of both prosecutions and that she was a key material witness in another case and in this case.
She was a witness in this case who had provided information in another murder case. And the trial assistant in this case had conferred with that other trial assistant in the other murder case, in the McQueen case, about any additional information that required to be disclosed. The AUSA in this case, McMillan, did not have the benefit of the transcript at the time, and therefore relied on the summary of the witness's statements at trial. What this AUSA, Ms. Bach, had revealed in her pretrial disclosure was that Ms. Harris had used multiple names on different occasions, which was the basis of, and Your Honor, Judge Blackburn-Rigsby, Your Honor was quoting from defense counsel's extensive closing argument attacking Ms. Harris based on her use of multiple names. In fact, what trial counsel did was elicit from Ms. Harris that she used multiple different names depending on the circumstances. So I believe Your Honor is correct that the substance of the same information was elicited at trial. The only thing that motions counsel argued that he did not have at his disposal was the ability to label Ms. Harris a liar by her own alleged admission in context of describing this other personality, Carmela, in the McQueen case. And
And the trial judge, in his order, sort of refutes that line of argument on the grounds that some of the cross-examination clearly implied
yes,
some untruths on the part of Ms. Harrison. And so that sort of gets us to the point that you made initially about the sort of new argument for the first time on appeal about the importance and prominence
yes.
and need for further exploration of the PTSD diagnosis.
Yes, indeed. Mr. Moore, who was the motions hearing attorney, had acknowledged that although Ms. Harris had told defense counsel in the McMillan case that she was crazy, there was no medical record to suggest that she was crazy, and that was untrue. And as Judge Christian recognized, having reviewed the McQueen transcript, having the opportunity to review the medical records that Judge Satterfield reviewed, agreed that there was nothing that would have provided any additional fodder for cross-examination. And trial counsel did not suggest, either in either McQueen case or in this case, that there was any further relevant cross-examination based on this witness's potential mental health history. So that's why my argument is that this position that counsel is currently taking is inconsistent with counsel's position in the trial court. And that was, and moreover, that a position was not unreasonable in light of Judge Satterfield's rulings, which no person has challenged at any stage of the proceedings, having had the benefit. Indeed, Judge Satterfield was the one who had Ms. Harris arrested on a material witness warrant, and was the one who had caused Ms. Harris to be detained at the DC jail. And he had even commented during that transcript, he had dealt with her over several months and had no reason to question her mental health. So there is no record to support the relevance of a post-traumatic stress disorder in the past to Ms. Harris's ability to relate and recall the events at issue here. As trial counsel, as defense counsel noted, the sole argument was the liar, whether he could have elicited whether Ms. Harris had admitted to being a liar. And as Judge Christian noted, even assuming that counsel were successful in eliciting that admission, the explanation would have been, just as in the McQueen case, that Ms. Harris was trying to say anything to get out of jail and to get the defense counsel to leave her alone because she had been contacted by them repeatedly and had been afraid for herself and her children as a result of that contact. In fact, Judge Christian at the hearing in December 7th of 2016 went through that mock exercise with defense counsel and the government's counsel. And based on that, and based on the entire record before Judge Christian, he had a basis to find, and Judge Christian had presided over the trial, so heard all of the witnesses' testimony, that this evidence, had it been produced timely, would not have undermined the verdict in this case. And that finding is entitled to substantial deference, as this court has recognized in Turner and in other cases, because in this case, Judge Christian heard the testimony of all four witnesses and found that the circumstantial case was strong. As this court recognized on direct appeal, the identifications of defendant and his van were corroborated by multiple identifications.
Let me sort of ask you the same question, Ms. Carroll, that I asked Mr. Kirsch a moment ago. You know, Ms. Harris's testimony seemed to be stronger or perhaps most critical with respect to the robbery charge on which there was a mistrial. But she did also offer critical testimony with respect to the murder charge. How do we weigh that and its validity in light of some of the other witnesses who also testified?
I think Your Honor is correct that Judge Christian recognized that to the extent that Ms. Harris's testimony was essential to that count, the fact that the jury hung on that count suggested that they had already discounted her testimony. Indeed, Judge Christian had found, based on the cross-examination and argument from defense counsel, her testimony had largely a rational juror would have found that she had a propensity to lie. And that was the basis for Judge Christian's finding that it may have been, in large measure, why the jury hung. Now, there were three other witnesses who there's no dispute that they were on the scene. Two of them did enter into cooperation agreements, but all of that information had been placed before the jury and their testimony had been credited. The other the first witness, Mr. Ringo, had known appellant his entire life. He had pled guilty. He had misdemeanor charges. He had talked to the police, but had not reported the information that he'd seen that night because, as he explained, he was still living in the area. When he moved to South Carolina and he learned that he had these outstanding warrants, he returned to the district and turned himself in. And he volunteered this information that he had seen he had seen the defendant in this struggle with the victim, and that he saw a spark coming from the defendant, but he couldn't see the gun. He couldn't see a gun in the defendant's hand. That he saw the defendant get back into he described it as a purplish van, and he ran into a building, but heard the van leaving in a rush. Now, there's no question that Mr. Ringo was on the scene. That information was corroborated by Laverne Chapman, a high school student who had no bias. There's no alleged bias with respect to any of this information in the case. He placed Mr. Ringo on the scene. In addition, Mr. Berry had described, who didn't identify the defendant, who only saw the driver of this maroon van from the back or side, get out, point a gun at the victim before getting out of the car, and then engage in a same tussle over, grabbing his coat collar, that he described and demonstrated, just as Mr. Ringo demonstrated in the well of the court for the jury. And that description was consistent with Ringo, and both of those descriptions were consistent with the medical evidence, the expert testimony, which indicated that the victim sustained abrasions to his hand, his head, immediately before his death, and that the shooter had fired the gun from a very close distance, the barrel being between 18 and 24 inches from the victim's eye, based on the stippling around his eye. So the medical evidence corroborated the witness testimony. And this case was not based solely around Ms. Harris, but rather this is a classic circumstantial case, that the strength of it came through the corroboration from multiple different sources that had no evidence of any suggestion of any reason to overlap. And then finally, Mr. Chapman, young Mr. Chapman, 18 years old, who comes around the corner, had heard the gunshots, turns around the corner, sees the decedent Mr. Boone lying on the ground, and sees the maroon van driving out. He did not identify the defendant, but he had testified that he had seen the defendant in that van regularly. Now, all of these witnesses, and I would note, Ms. Harris did not see the shooting. She testified, and defense counsel elicited the fact that her back was to the shooting at the time. She never placed a gun in the defendant's hand, and she didn't even see how the defendant left, other than the fact that he was gone when she turned around and the van was driving away. So my argument is, yes, sir. I'm sorry.
Counsel.
Yes.
Didn't Ms. Harris and the defendant talk about shooting later together? I mean, didn't they have some conversation?
Ms. Harris had said that she had seen defendant after the shooting, and she had restated those words that she heard the defendant say, something, and I'm sorry that the words escape me, that she had used when she encountered defendant. I believe it's something about, you know what this is. I'm not sure what impact. I don't know that she even testified in the McQueen trial that she never told, I'm sorry, not the McQueen trial, in this trial, that she never told the defendant she witnessed what happened, or that she was testifying for the government, or that she was going to testify for the government.
Okay, I just have one other question. At pages 29 and 30 of your brief, you refer to an admission by
The defendant.
yeah, in the to detectives in their notes, which of course was hearsay, and it was not apparently introduced in the trial. But I was curious just exactly what point you were making.
So the point was, this was noted by the government in their opposition to the defendant's motion in the trial court. And in addition to the evidence that we have in the McQueen trial, Ms. Harris's explanation for her reference to the multiple personalities, the government had at its disposal this additional evidence that the government could have called the detective, not necessarily provided, not through notes, but the government could have called the detective at trial had it needed to shore up any evidence, had Ms. Harris's testimony been critical, or had Ms. Harris's testimony been such that they did not believe they could establish appellant's presence in the block at the time. Because defendant admitted, after initially denying it, he admitted he drove his van through the block at the time of the murder. And that evidence could have been a response to any additional cross-examination that defense counsel did not have the opportunity. So the trial court had the opportunity to view all of the potential impeachment evidence, as well as the response to it and the weight of that evidence in light of the other compelling circumstantial evidence in the case.
Would be admissible as an admission, or what?
Party opponent.
What would be?
Defendant's statements would be admitted as the statements of a party opponent.
Right. Is there anything else, Ms. Carroll?
I'm sure I've forgotten something, Your Honor, but I would rely on, for the reasons articulated in our brief, that Judge Christian's order should be affirmed. Thank you.
All right. Thank you. Mr. Kirsch, we'll give you a couple minutes for rebuttal.
Okay, thank you. Yeah, when we're talking about a Brady violation, and clearly there's a Brady violation here because this information is exculpatory, it's impeaching, primarily impeaching, and it was suppressed.
But was any explanation, further explanation given to defense counsel that you're aware of as to why the information wasn't disclosed sooner?
No, I agree with Ms. Carroll that my understanding, and it's consistent with the government, is that it was learned by trial counsel as they were getting ready and preparing for a case, and that they learned that Ms. Harris had testified in another case, so they did some additional exploration. But again, in the context of Brady, fault or the reasons really doesn't matter. What matters is that the defendant is deprived of the full opportunity to impeach the witness. And this witness, Ms. Harris, my position is that she clearly was the centerpiece of the government's case. Without Ms. Harris, the government really would have had a terribly difficult time in obtaining a conviction. And I also want to go back and address comments made about Judge Satterfield, who was the presiding judge.
Or with Ms. Harris, they could potentially have run, or with further impeachment of Ms. Harris, as you suggest, could they have run the risk of a mistrial on the other counts too? If you are of the view that potentially the jury's lack of confidence in her credibility is what led in part to the mistrial on the robbery charge.
Well, it's always hard to try to figure out why a jury does things, why there's a mistrial on counts, why they convict or why they acquit. So it's hard to speculate. But with respect to Ms. Harris, she was so critical because she puts Mr. McMillian on the scene. I mean, that's the critical part of the case. Clearly, his van is there, but putting his person on the scene, the government has to make that connection. And I don't believe they could have credibly made that connection without Ms. Harris. These other witnesses were all so tainted. And just by talking about Mr. Ringo, he says he didn't see a gun. He leaves before the police arrives. He waits years, literally years, to tell his story. And the only reason he comes back to DC to tell this story, and I would submit to the court, he was not just telling this story, he was trying to sell this story, is because he realized there are multiple warrants for him and he wanted to cut himself a deal. And that's exactly what he got. Now, that doesn't mean he's not qualified to testify, but it certainly goes to his credibility. The same with Ms. Harris. I don't quibble with Judge Satterfield's conclusion that she was competent to testify, but being competent and having your testimony undermined by impeachment of a serious medical ailment are two separate things. And that's the crux of my argument, is that the government clearly would have had a difficult time. The fact that a thorough impeachment was not conducted because of the suppression of relevant, and I would submit very material evidence, there cannot be confidence in this verdict. And that's why we're seeking a reversal or a remand, deciding on the plain error issue. And we would submit on that.
All right, thank you. I'd like to thank both counsel for your briefs and your arguments today. And the matter is under advisement, will be taken under advisement by the court. Thank you.
Thank you, Your Honor.
Thank you, Your Honor. Thank you very much.
All right, we have a second case this morning. And counsel for the second case are entering our virtual courtroom. Good morning, Mrs. Simone.
Good morning, Your Honor.
Did I pronounce your name correctly, counsel?
It's Besiso.
All right, good morning, Mr. Besiso.
Good morning, Your Honor.
All right, Mr. Brackish is arguing for the government, I understand.
Yes, Chief Judge, it says he's still joining. It took Aaron Curl a couple of minutes to come in. Here he comes. Okay, it took him a few minutes to get here.
That's
Okay.
all right.
Okay, all right.
Good morning, Mr. Brackish. Can you hear us? I'm not sure if Mr. Brackish's audio or camera are fully connected yet. We'll give him another moment. All right, Mr. Brackish, I can see your audio is connected, but it appears that you're on mute. Can you hear us?
I can hear you now, Your Honor.
All right, good morning. We're not able to see you on on video. Will you be able to
I
join us?
can't
by
yet see
video?
you loading properly,
yes.
so feel free to begin.
All right, we can see
I can
you
see
and
now.
hear you. Are you able to hear us?
Yes, Your Honor.
Okay, then I'm going to call our second case for the morning, Kyrie Napper versus United States. Counsel, are you all ready to proceed?
I am, Your Honor.
Yes, Your Honor.
Mr. Paciso?
May it please the court, Your Honor. Good morning, Your Honor. I'm Omar Basiso. I am counsel for the appellant Kyrie Napper. The issue in this appeal is whether, the appellant was found guilty in a bench trial. And the issue is whether the government actually proved beyond a reasonable doubt that the unlawful entry occurred without lawful authority. In this case, the evidence was clear that the appellant was not served with a valid barring notice. One
Mr.
officer,
Paciso, I apologize for interrupting you. I just wanted to confirm whether you wanted to reserve a couple minutes of your time for rebuttal argument.
yes, Your Honor, I'd like to reserve 2 minutes.
Okay, thank you. You can continue.
Okay. So only one officer testified for the government in this case. He was not the officer. He was a DCHA officer who did not fill out the actual barring notice. Throughout the trial, the testimony established that he accompanied another officer to the cell block where the other officer approached the defendant, but the officer was sitting so far away, he didn't even hear what was said to the appellant. There was no testimony that Officer Harrison actually heard the appellant being advised about what the specific boundaries of the property that he was barred from were, whether or not he was barred for a specific period of time, whether or not there were any exceptions to that barring notice, or the basis of that notice. There was some testimony in this case that the officer had a prior interaction with him where he orally told him, in the transcript, he says, I told him I knew he was barred, but he didn't.
Mr. Paciso, if I could interrupt again, just to clarify my understanding of some of the facts here. There was an understanding of the basis for why Mr. Napper was barred. And it related back to an assault in 2017 on the officer. I believe it was Officer Harrison, Officer Joseph. And then there were some subsequent encounters that the special police officer for the DC Housing Authority had with Mr. Napper prior to the arrest that is at issue in this case. And we do have the officer's testimony, Officer Harrison's testimony, that at the time of the arrest and the assault in 2017 and in July of 2018, and then the second time in June or July of 2018, that he did tell Mr. Napper, after finding him on the premises, that he was barred and was not supposed to be on the premises. So in the encounter that led to the arrest here, at least the trial judge found that there was some prior notification from Officer Harrison to the appellant that he was barred from the property. Then there was also the testimony, which the trial judge found credible, that Officer Harrison witnessed Officer Joseph having a conversation with the appellant in the cell block, where Officer Joseph had the barring notice in his hand. And based on that, the trial judge found that there was a basis to reasonably infer that, again, on that occasion, it was communicated to Mr. Napper that he was barred from the premises.
That's correct, Your Honor. I'd like to address several of those points. With regards to the alleged oral notice, Officer Harrison didn't—
Which one? Which alleged?
So during the prior summer encounter before this arrest, when the officer was asked on cross-examination if he showed him the barring notice on that subsequent meeting that they had, he said he didn't show him the barring notice. he was asked if he explained to him what the boundaries of the Lincoln Heights property were. He said he did not. He was asked if he explained to him the length of time that he was barred from that area. He did not. There was no testimony that explained to him whether there are any exceptions to that notice. Now, with regards to the written notice that was, the judge found that, yes, they had gone to the cell block to deliver that notice, but the officer testified that he didn't actually see the notice hand delivered to the appellant, nor was there any testimony that the appellant tried to, shove the officer away or somehow did something to reject service of that notice. There was no actual testimony about the actual words that were exchanged. So the court would be speculating about what was said, whether he was actually advised in the courthouse. Now, had that officer appeared himself and testified as to what he said to the appellant, I think that could be different, but he did not testify. Officer Joseph was not called as a witness. So all we're left with is Officer Harrison telling the court that he saw another officer approach the appellant and show him something, not that he was specifically advised at that time that he was barred from Lincoln Heights property for a set period of time, and that he was given an explanation of these complex boundaries, that he was told, look, you cannot come here under any circumstances. That was not in evidence. So
Mr. Basiso, excuse me for interrupting, but is it your position that absent a barring notice, you could never, ever have an unlawful entry charge proceeded against someone for being in the public housing project? I mean, is a notice absolutely essential to an unlawful entry conviction in public housing?
yes, Your Honor, I believe under DCHA cases, there are regulations that govern these specific body of cases that involve DCHA. And the DCMR has specific.
You're saying they're exclusive. That is to say, unlawful entry can be proved anywhere else in the city based on oral testimony. But if it's public housing, you've got to have one of these barring notices that I suppose you haven't said that the AM or PM box wasn't checked. Was that also a deficiency? In other words, what you're saying here is that unless there's totally technical compliance, you can never get an unlawful entry conviction. Is that right?
Yes, Your Honor. I believe that these DCMR regulations are not just merely technical requirements. They have to be followed for a reason. They exist for a
So they're
reason.
modifying the statute?
Yes, Your Honor. So yes, these regulations exist for a reason. They note that a person needs to be either given written notice or attempted written delivery of that notice. And that notice should say where the specific boundaries of the area that they're barred from is, and the length of period of time. It's kind of similar. I'm reminded of the Osborne case, which involved revocation, where it said, for that revocation to be meaningful, it has to have a start date and an end date. And in some ways, if we're going to hold people criminally accountable and criminally liable for violating a notice, these regulations should be followed so that a person knows where they're barred from and the length of time that they're barred, and whether there are any exceptions to that. Now, in this case, there may have been a discussion about the basis that it arose from an assault, but those other requirements were not met.
Yeah, but the statute doesn't require a written notice, right? 223302A, which is the unlawful entry statute, does not have a requirement of written notice. And our cases have sort of interpreted the statute to mean that the person should have known or reasonably should have understood that they are barred.
That is correct.
So is where the regulations seem to exceed or perhaps differ from the statute, doesn't the statute govern? In other words, don't these regs here arguably conflict with the statute that they're supposed to be interpreting?
I think in these specific cases, in the DCHA cases, the regulations need to be taken account with the statute. So if we're talking about private property, that could be different. But in the DC Housing Authority cases, these regulations exist for a reason and they should be followed. yes, it's true that in other cases, you may not need a written notice, but even if we were to just hypothetically assume that, okay, so even in the case where we're proceeding on an oral theory, here the oral notice was wholly insufficient in any case. The officer never testified that he orally told him what the boundaries were or the length of time he was barred or other requirements of this barring notice. When we look at the DCMR regulations, there's even a section about how long that period could be. There's a 60-day period. There are different periods for a certain number of infractions. So there is an issue about the length of time that a person could be barred. And I think that these regulations define the scope of the executive authority for the people who are doing the barring, so that innocent people are not being held criminally liable in the case where they're not properly informed of what the exact boundary of where they cannot enter and for the period of time they cannot enter.
Well, counsel, how far would you take it? In other words, certainly it makes sense that there has to be clear notice what the boundaries are of a place you're not supposed to enter. Let's suppose that everything on this barring notice was filled in except AM or PM. You know what I'm talking about down there in the bottom of that area. Would you say that the failure to do that was fatal to a conviction?
Your Honor, what I would respond to that is that I think at the bare minimum, we should at least give the person the boundaries, the time, the reason for the notice. And I think that something like the AM or the PM, I believe that the law is meant to be read in a reasonable way, in a way that's fair to the person. Now, if we're talking about the person not even being informed of the exact boundaries, I think that's a bigger problem than whether or not it's AM or PM. But I do believe that compliance with the regulations is required.
Now,
Battisto.
did you raise this argument below? Or are you raising this argument about the compliance with the technical requirements of the written notice for the first time on appeal?
I believe that trial counsel pressed the court about some of the service issues in this case, but I think that this is a legal error. So I believe that this is de novo review, because this is the court erring as a matter of law when it found that the evidence was sufficient to support a finding that one of the elements of without lawful entry was met. So I really just want to emphasize here that, if the written notice was not served, and if the oral notice was so wholly deficient that it didn't even tell the appellant the boundaries of the length of time, that the conviction cannot be sustained based on those factors.
All right, thank you. I'm sorry, Judge Glickman, you had a question.
That's okay. Mr. Battisto has used up his time. I don't want to trespass on his rebuttal time.
Thank you, Your Honor.
All right. Thank you. Mr. Brackish?
Yes, Your Honor. Good morning. May it please the court, Adam Braskich for the United States. This case, Your Honors, involves a defendant who was barred from DCHA property for a legitimate reason and was barred by DCHA officers who were vested with authority to complete the barring process.
Did he know that? Did he know that he was barred? And did he know the extent and parameters of his barment? Is that a word?
I'm not sure either, Your Honor, but yes, I believe that he was. And the government presented evidence from 3 different occasions that I think together provided the trial court with ample basis to conclude that the defendant was on notice that he was barred from the Lincoln Heights property.
Did he know how long he was under the barring order or subject to the barring order? And how do we know he understood the extent and parameters of the barring notice and the duration of it?
So, Your Honor, I don't think in any unlawful entry case we can ever know what is in the defendant's mind, short of him articulating. I understand.
Let me rephrase. How do we know he was on notice and had been notified of the duration of the barring order and the parameters of the barring order?
So, Your Honor, the duration of the barring order and the parameters are both spelled out on the barring notice. And there's testimony that Officer Joseph approached the defendant in the cell block at Superior Court for the sole purpose of serving the notice on him. And then the testimony from the trial, which the court credited, is that the barring notice was shown to the defendant. He showed it to the defendant. And I think viewing the government's evidence in the light most favorable to the government, as this court must on appeal, that the trial court could, that the conclusion that one could draw and should draw is that information that was written on the barring notice was conveyed.
Can I just interrupt briefly for clarification of the timeline?
Yes.
Again, what is the date and time frame at which Officer Joseph showed or allegedly showed the barring notice to appellant in the cell block?
It's about 11 months prior to the arrest in the case that's on appeal, August 19th of 2017. And then
So it was following the arrest for the initial simple assault charge.
Correct, Your Honor. Yes, and the Mr. Basiso, my friend, referred to the boundaries, the time, the reason for the barring. I think all of that is clearly spelled out on the barring notice that was showed to the defendant in the cell block, and the boundaries are right at the top. The date and time of the service are on the notice, and also the reason for the barring, as well as the duration of the notice. It is articulated. The box is checked under the heading of extended bar, which refers to a 5-year notice, and it makes clear that he's barred for conduct that threatens the safety of a DCHA employee. So there is the evidence that this barring notice was completed. We have it as an exhibit, and it was shown to the defendant. And there's also the trial court's conclusion that he was put on notice at that time, which is not clearly erroneous. But there's also the second encounter, which is late June.
Before we get to this, Mr. Braskich, before we
Yes,
get
sir.
to the second encounter, may I ask you a hypothetical?
Yes.
Suppose the housing authority officer went to the cell block and met with Mr. Napper and said, "There's a bar order for you that's going to bar you from the Lincoln properties. Since you're in the cell block, I will leave it with your other property at the desk or wherever we put that stuff, and don't forget to get it." And suppose that's all that the officer tells Mr. Napper, so Mr. Napper knows there is a bar order for him, but for whatever reason, he doesn't get it later on. All he knows is that there's a bar order there for him. He doesn't know its precise terms. He knows it relates to the Lincoln properties for obvious reasons. Do you think that if Mr. Napper then shows up, as he did, at the Lincoln properties in violation of the terms of that bar order, he can properly be prosecuted for unlawful entry, essentially on the theory that he knew there was a bar order and had an obligation to know its terms?
So potentially, Your Honor, and I don't mean to be difficult, but I do think it depends on the reason why the defendant wouldn't have actually received the physical notice. What this court makes clear in order.
Well, the reason I'm giving you in the hypothetical is that the officer just was slipshod in the way he handled this. He could have taken the time to speak to Mr. Napper and tell him every particular item in the order, but in my hypothetical, he didn't do that.
I understand, Your
The
Honor.
reason I put that hypothetical in that way is because since that officer did not testify and Mr. Napper did not testify, we have no information in the record as to precisely what the officer said to him. It is a fair inference that the officer talked to Mr. Napper about the bar order. It's probably a fair inference, frankly, that he told him the main terms. And maybe that's enough to get you past the hurdle of a motion for judgment of acquittal. But I'd like you to speak to the hypothetical I've raised for you.
Right, Your Honor. And what I was trying to say is that it might depend on what happened after the defendant, had his hearing in C-10 and had the opportunity to retrieve the barring notice.
Well, let's say you forgot.
That
Well,
so
let's say they couldn't find it at the marshal's desk when they were giving him the rest of his property.
right, and then I think
Or let's say he didn't want to see it.
well, I think
pick your-
I think those are
pick
different,
your-
Your Honor.
It's-
The answer,
I agree, Let's assume it's the most benign of those things.
Okay, so
Defendant
the
point of
the
view.
reason I think that the answer might change is because the standard under Ortberg is that the defendant knew or should have known that he was barred. So if there was an error, a clerical error at the court, and they just lost the barring notice and couldn't give it to him, then I do not think a conviction could be sustained because the officer didn't bother to articulate the terms, and then to no fault of the defendant, he was never given proper notice. But if-
Why is it that if it's a new or should have known standard, why is it that if the defendant knows there is a bar order out there for him, he doesn't have an obligation before he returns to Lincoln to find out its terms?
the government could make the argument that he should have, called the DCHA authorities and figured out the answer to that. That's a plausible argument, Your Honor, but I think it's a tough one to say that he should have known if he did what the officer instructed, which is go to the cell block and say, "Where's my barring notice?" And then the authorities said, "Well, we lost it. We don't have it."
Well, since the record here in this case is completely silent as to what actually happened to the barring order that was brought to the cell block, or whether in fact the defendant ever got it, or if he didn't get it, why he didn't get it, where does that leave us with respect to the enforcement of that bar order? If you're not willing to go all the way and say it doesn't matter.
Well, Your Honor, I don't think it legally matters what happened to the physical barring notice and whether the defendant left the courthouse with it in his hand, because what
No,
matters.
if he was told, but the record
Right.
is also silent. It's an inference that has to be drawn. The record
Correct.
is also silent as to whether he was told the terms of the bar order.
Correct, but he was shown the barring order, which articulates all of the details that would need to be conveyed to the defendant in order for him to be properly put on notice.
See this, we got a barring order for you. Okay, you've seen it. That's enough.
It's possible that's how quick it went, Your Honor, but it's also possible that it was shown to the defendant and that he read it and understood it. The most important
It's
terms
possible
are,
get the government beyond a reason to a conviction beyond a reasonable doubt.
yes, I think it's certainly a reasonable view of the facts for the trial court to draw, that because he was shown the barring notice, that the officer was there for the purpose of serving it to him, that he would have shown it to him long enough for him to look at it and read its terms.
Well, I'm inclined to agree. And so ultimately, the point of my hypothetical may simply be everything rests on whether we think the judge fairly could infer beyond a reasonable doubt that the officer who went over to speak to Mr. Napper either told him or showed him or read to him these specific terms. Now, Mr. Besiso argues that it's speculation for us, for the judge to assume or to find that all those things were said or shown to Mr. Napper. The witness who testified could not say those, could say all that. Could not say all that. So where does that leave us?
I think the distinction that needs to be drawn here, Your Honor, is between direct evidence and circumstantial evidence. And what we have in this case is perhaps circumstantial evidence that the defendant was put on notice, but that doesn't mean that the trial court could not rely on that form of evidence. The officer, showed the barring notice. It was going up to the defendant specifically for the purpose of serving the notice and putting the defendant on notice that he was barred. And in light of those facts, I think it's perfectly reasonable for the trial court to infer that he in fact was advised in the cell block, and that is not just mere speculation. But I think that
Why did the officer not fill out the information on the form, which the form asks for, as to when the defendant was advised?
I have no information from the record about why the officer didn't fill it out. It's even
I
possible.
mean, it could be argued, for example, that the failure to fill that information out implies or undercuts the inference that Mr. Napper actually was told the details at that time.
I would say two things in response to that, Your Honor. One is that while it may be reasonable to draw that conclusion, it doesn't necessarily mean that the trial court was obligated to draw that conclusion. Also, I believe that the defense waived the argument that the checking or not checking of the box could go to the actual proof of whether or not it was served, because he objected to this, the substance, the declarations on the notice, and Judge Broderick and defense counsel.
No, it's not being used for the truth of the matter asserted. It's simply the absence of filling that out may have some evidentiary significance as to how careful the housing authority officer was when he delivered the notice.
Right. This may be too fine a point, but I think that, you know, silence where one would have been expected to make a declaration could be hearsay that the trial court.
But that, I regard this as a secondary issue in any event.
Yeah.
The real issue is whether the trial judge could, on the facts, the scanty facts provided to us at trial, infer beyond a reasonable doubt that Mr. Napper knew enough to know that he was barred from the place he returned to.
Yes, Your Honor. And I think that the conclusion that the trial court drew is bolstered by the other two encounters. I just wanted to highlight a couple facts about those encounters. In the late June or early July of 2018 encounter, the record shows that the trial transcript shows that the defendant was arrested in the very same block where he was then arrested in the case that's now on appeal, the 300 block of 50th Street. So he's arrested about a month before by the same officer who tells him, you're barred from Lincoln Heights property. And it's not just a warning, he actually arrests him for unlawful entry for being there. And then on the date of the actual...
What happened in that case, by the way? What was the outcome of that case?
That case was dismissed after it was papered for reasons that are not entirely clear and certainly aren't in the record. But I think there was some confusion about the police paperwork because the charging document referred to both that date, which was June 21st of 2018, and also citing the day before. And there was some problem with...
I mean, I did idly wonder whether the dismissal of that charge had any bearing on what significance we should attach to it.
No, and my review of the file outside of the record, Your Honor, is that there didn't have to do with the sufficiency of the barring notice, but rather the police reports about the encounters. But I think just with the short time I have left, I wanted to emphasize that the third encounter also bolsters the trial court's conclusion that the defendant was on notice because he fled just at the mere sight of Officer Harrison as soon as he stepped out of the door at 312 50th Street. As soon as he saw this officer who had just arrested him and warned him the month before, he took off running, and the trial court...
And that was in the same location as the prior to arrest?
Correct, Your Honor. So on page 43 of the trial transcript, it makes clear that the second encounter, the warning, is in the 300 block of 50th Street, and then that's the same block that he's in a month later when he's arrested. So those facts taken together, Your Honor, I think show that the defendant was put on notice, and that's really all that the statute requires. And that's the important thing here, is not what the regulations state, but what this court has held and what the statute requires for a conviction for unlawful entry, which is just notice that the defendant was entering against the will of the lawful owner. And
Counsel, excuse me, counsel, do you rely at all on the Hay case? Judge Oberle's comments in there about the barring notice.
Are you referring to the delivery or attempted delivery of the barring notice, Your Honor? So I think we note briefly in our brief that doesn't strike us as problematic, that while the appellant in that case argued that at least attempted service was required, the court didn't need to grapple with the question of whether or not a barring notice was required. As to Your Honor's, first hypothetical during my friend's time about whether a barring notice is required in all DCHA cases, what the court saw was that there was at the very least attempted service, and that was sufficient to extinguish that claim and move on. And I think the court has the same thing here. At the very least, there's attempted service of a barring notice from the evidence that you have of what happens in the cell block, but even if the court were not satisfied that there were attempted service, to answer Your Honor's question, Judge Farron, our position would be that the barring notice itself is not required for a UE conviction.
Thank you.
So I see my time has run, Your Honors. If there are no further questions, I'll submit, and we would ask that the judgment of the Superior Court be affirmed.
All right, thank you, Mr. Breskich. Mr. Besiso, you had, I believe, about 3 minutes, maybe a little more than 3 minutes of your time remaining, and you can use that for your rebuttal.
Yes, Your Honor. I really want to emphasize some things here. Any factual finding is simply not supported by the record in this case. There's no really way to say it other than it really is a stretch to say beyond a reasonable doubt in a case where we're holding somebody criminally liable that Mr. Napper was told what the boundaries were and the length of time that he was barred. Even in the Hay case, the court notes in Hay, Officer Douglas explained in that case, the details of the barring notice, including a description of the boundaries of Garfield Terrace and the 5-year duration of the bar. He explained to Hay that he is barred from the property. That under no circumstances is he permitted to enter back onto the property, even if he's invited by a guest. In this case, we don't have anything like that.
We do have the fact, don't we, Mr. Besiso, that 3 different times he is either arrested or stopped in the same location, in the 300 block of the Lincoln Terrace public housing project. And each time he's told that he's not supposed to be there. I mean, so maybe the argument about the lack of clarity about the boundaries would be different if he's caught on the other side of the housing development in a completely different unit or building or area. But here he's consistently in the same spot and he's consistently told he's not supposed to be in that spot. If you have any other questions, that piece seems to be pretty clear.
Yes, Your Honor. I don't want to concede the point about the boundary, but I do want to point that what about the length of time? What about the exceptions to a barring notice? What about, there are other things. It doesn't just boil down to the boundary alone. I mean, so some people could be barred, somebody could be told hypothetically you're barred for 10 days, or they could be told 2 weeks, or they could not be given a time at all. So there's a big difference between an officer testifying that I told him that he was barred for 5 years. It's 2017. You can't come back here until 2022. And if they go through the painstaking details of the boundaries and what the exceptions are and everything, that's a different case. But here, it's really a stretch. We'd really be speculating about what was said to him in C-10. Officer Harrison was even asked, you don't know what was said to him, right? No, I don't. This is on page 24 of the transcript. You've referenced a pink slip. I mean, you don't know if he gave him any piece of paper, right? He says, yes, he doesn't know if he gave him a piece of paper. He says how did he show it to him? I mean, did he flash it? Maybe he doesn't like, I mean, there's so many situations that could have happened that we're really stretching. We're really speculating about what was said in the cell block. That leaves us with the oral notice, but that oral notice is not sufficient either because it doesn't really specify to the appellant how long he's barred and other circumstances of the barring notice. Even if we took out the boundary issue aside because he was found in a more direct area, it's still an issue that he's not told about the period of time and other things that people are entitled to know before we hold them criminally liable and responsible. So to boil it down, I mean, can we say beyond a reasonable doubt that Mr. Napper was adequately informed, was sufficiently informed? Like, what is there in the record that lets us know that, yes, Mr. Napper was told where he was barred from, how long he was barred from, he was given sufficient notice of what is required to make him guilty of the criminal offense of unlawful entry. And I just simply do not see that.
Mr. Besiso, if I may ask you, if Mr. Napper knew he was barred, but he said to himself, gee, I don't know the exact terms. I don't know for how long. I don't know some other things. Could he have found out? Is there some way he could have inquired and determined what the details that he wanted or needed to know were?
There could be ways to do that, Your Honor. but I don't believe that it goes towards the defendant's guilt. So
Why
there
is
could be
that?
ways that
Why is that?
Because-
If the defendant knows that there is a bar order requiring him for some some period of time, he just doesn't know what it is, for example, from that property, or he doesn't know the exact parameters, but he knows that he's barred from Lincoln Apartments. And why is it that it's okay for him to say, well, I don't know, I think I'll rely on my ignorance, I will go visit Lincoln after 6 months or whatever, and if it turns out I'm wrong and I was barred for a longer period of time, I'll just say that I didn't know because I didn't inquire. Is that okay? Is it permissible to convict him under those circumstances for unlawful entry?
well,
Or does he have
I'd
an
like to,
ironclad defense there that he wasn't given the precise information and he was under no obligation to find out more?
I believe that the obligation for that information is imposed on the people who seek to bar the
No
individual.
question. No question.
So I don't
Absolutely.
believe, I apologize, Your Honor. Yeah, I don't believe that they have such a duty. So it's the obligation, responsibility of the people to do that. I'm not familiar with any case where someone's been found guilty of unlawful entry because they didn't go to a management office to clarify the terms. I think the way I'm approaching this case is this is a case brought by the government. They're seeking to hold somebody criminally accountable and responsible for an offense, and they've not proven all elements of the offense. They have not shown that he was adequately, sufficiently informed of the specific terms of him being barred from this.
But is that an
DCA.
element of the offense though, Mr. Basiso? That he was sufficiently and specifically and informed in writing with all of the boxes checked? That's included in the regulation, but it's not in the statute and it's not in how we've interpreted our case law. We say he knew or should have known. And here he knew he was barred. Can't we also go a step further and say, and should have known the parameters of that barring notice?
Your Honor, I would actually have to respectfully disagree as to whether he knew he was barred, because the timing issue is important. I can't concede that he knew that he was barred. I cannot concede that based on the facts on this record. Based on the fact that if there's no evidence or testimony indicating to him exactly the length of period of time that he was barred, I cannot say that he knew that he was barred.
Do you think that it was a fair inference for the trial judge to make that when the housing authority officer spoke to him in the cell block, the housing authority officer, at a minimum, told him that you are going to be barred from the Lincoln Apartments?
Your Honor, my understanding is that Officer Harrison tried to avoid the appellant and did not seek to interact with him. Had another officer, Joseph.
Yes, I understand that. I understand. That's why I said that's why I didn't give the name, because I've forgotten the name of the other officer. The housing authority officer, the judge knows that two housing authority officers went there to the cell block for the specific purpose of telling Mr. Napper that he was barred from the Lincoln Apartments. One officer sees the other take the bar notice and walk over to Mr. Napper and spend some period of time talking to him, and at least shows him in some way the bar order. Now, I understand how slipshod all this was, but could the judge at the very least infer beyond a reasonable doubt that one thing Mr. Napper knew after that conversation was that he was being barred from the Lincoln Apartments? Perhaps the judge could not infer beyond a reasonable doubt that he knew all the details. That's, I guess, something we'll have to think about. The two of you at counsel have argued about it, but I'm asking you the question, could the judge at least fairly infer beyond a reasonable doubt that after that conversation in the cell block, Mr. Napper knew he was being barred from the Lincoln Apartments?
Your Honor, my answer to that is absolutely not. Absolutely not. I do not think that was a fair inference at all. based on these facts.
Explain why not.
I don't believe that one officer seeing another officer approach the defendant is enough to say that without him even hearing what was said. I mean, there's also testimony about how far he was sitting, and that he was sitting so far he couldn't even hear the words that were exchanged. And in addition, when he says, you know, he doesn't even know if he gave him a piece of paper either. I mean, I think what the court is getting at, to support more of a reasonable inference, you would have needed the testimony of either Officer Joseph himself, or you would have needed Harrison in a position where he can say, yes, I mean, I was close enough, I heard them, or I was close enough, I saw him hand the paper and saw Mr. Napa reject it or push him away or something of that nature. But here, the testimony is so limited. You know, I refer to page 24 of the transcript because I think that that's key. And I don't think that beyond a reasonable doubt that inference can be made. We have no idea what was said. Maybe the other officer was new. Maybe he didn't like Mr. Knapp. I mean, there's so many circumstances that are perfectly reasonable, perfectly plausible that could have happened. I mean, we're talking about C10 here. I mean, this is the C10 courtroom, which is, you know, where they do the arraignment and stuff. And there's a lot going on there. And for us to say, well, you know, he must have been advised because that's the purpose that they went there for. That might have been the purpose, but that's not, it's very possible that that's not what happened, even if that's what they intended to do when they went to the cell block. So to answer your question, Your Honor, I would say absolutely not. I don't believe that the inference was the right inference to make by the trial court.
All right, thank you.
Thank you, Your Honor.
Mr. Cifo, Mr. Braskich, thank both counsel for your arguments and your briefs today. And your case is submitted, and that will conclude our oral arguments for today.
Thank you, Your Honor.
This honorable court is now adjourned.
Counsel, you're both free to exit our virtual courtroom at this time. Thank you.
Thank you, Your Honor. I'm about to leave the meeting. Thank you.
Thank you, Your Honor.
Okay, Chief Judge, I'm ready to make you the co-host. So y'all can go back in the conference room and converge.
Mhm.
There we go. Wait a minute, wait a minute.
Okay, I'm showing that we're still recording.
Oh, let me